Rosenthal. Mr. Smith, you have 4 minutes remaining.
Thank you, Mr. Chief Justice. I have just a couple of points to make. I thought I might address this question of what it was that we proved in the record below and whether or not we have, as a result, adequately teed up the issues before the court without having put in evidence directly that this was a non-coercive act or a non-commercial act or a non-public act or things of that kind. Our position is that this is a criminal statute that has only 2 elements. It has a list of particular kinds of sexual intimacy that you're not allowed to engage in, and they have to prove as well that the 2 people involved were of the same sex. There was a complaint that was filed that listed those 2 elements. My clients pleaded no contest to those 2 elements, but said that they're an insufficient basis for imposing criminal liability on them because, first of all, they invade fundamental rights, and second of all, because the law is discriminatory. While it's supposedly got a moral basis, it's a discriminatory morality, a morality imposed only on one category of couples in a state which does not penalize in any way adultery, fornication, or sodomy for people of couples that have a different sex. Those were the arguments that were made, and so our position is that the statute is unconstitutional both facially and as applied here because the state purports to impose liability based on those 2 elements alone and that they are a constitutionally insufficient basis both for fundamental rights reasons and because it's a discriminatory statute. The other point I thought I might just address for the moment is the public health rationale, which didn't come up before. Essentially what the facts are, and I think this comes out to a large extent is undisputed in the amicus briefing, the issue is not briefed in here because the Texas brief doesn't even attempt to make this argument, but it is the facts are that if this is the line between safe and unsafe forms of sexual intimacy, it's as if the law cuts right across it, regulating some of the most safe forms of sexual activity possible, including, for example, lots of same-sex activity involving women, and leaving completely unregulated all sorts of forms of unsafe sexual activity involving different sex couples. So if there was ever a case of a law where the fit is egregiously improper and insufficient to justify the law under the rational basis test, this would be such a case. Unless the Court has further questions, thank you very much.
Thank you, Mr. Smith. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.